Resuming debate, the honourable member for Toronto-Danforth.
Thank you, Mr. Speaker. The Nuclear Terrorism Act, currently in the form of Bill S-9, will amend the criminal code to align our law with obligations under two international agreements, as the Parliamentary Secretary has so ably outlined. One is ICSANT, the International Convention for the Suppression of Acts of Nuclear Terrorism of 2005, and an amendment to another treaty, also this amendment was 2005, the amendment to the Convention for the Physical Protection of Nuclear Materials. Now, in broad terms, these two instruments, along with the underlying Convention for the Physical Protection of Nuclear Materials, deal with both protection of radioactive material, nuclear material and nuclear facilities, and protection from nuclear or radioactive devices. Now, the creation of criminal law offenses is one aspect of the protection scheme, alongside ensuring there is a broad, in essence, a kind of universal jurisdiction to prosecute for most aspects of these offenses. Now, the present bill, S-9, is overdue if one looks at the dates of the two instruments, both 2005, although this delay is mitigated by the fact that Canada is not yet bound to either instrument because it has not yet ratified. We've signed, but that's not the same thing as ratification. So Bill S-9, its passage will put us in a position to be in compliance and thus to ratify. But why we have left this combined ratification and implementation so long does remain a mystery to me, Mr. Speaker, despite the answer just given by the Parliamentary Secretary. This is not a controversial bill from any side of the House, and I can't imagine a minority parliament would have held it up. Now, the NDP very much supports the bill, as I've already indicated, supports this bill going to committee, and we will vote for it at second reading, and we expect to do so at third reading as well. Overall, we are completely behind the bill as a necessary measure as part of Canada's international cooperation against threats related to nuclear terrorism of various forms. Now, in a world of heightened technological sophistication that increases the ability to steal material, attack installations, make radioactive devices, and so on, it is impossible to overstate the importance of such cooperation and indeed Canada's role in that cooperation. Now, we wish to see this bill become law as rapidly as possible. At the same time, we also emphasize that some close technical scrutiny of the bill in committee is still called for to ensure that it has indeed been drafted in the best way to fulfill our obligations under these two treaties, rather so that we can then go on and not be in non-compliance once we ratify. Now, it may be that some slight amendments will be needed in committee. Now, I say this for three reasons. The first reason is there was what seems to have been a major omission in the government's bill that went to the Senate before now coming to us. What was that omission? Well, I referred to it in my question just now to the Parliamentary Secretary. Whereas ICSANT's Article 2(1)A includes the offence of making a radioactive device, Bill S-9 in its original form before the Senate did not include this activity, despite mentioning every other conceivable form of activity that also were in the two treaties: possession, use, transport, export, import, alteration, disposal. Now, the Senate caught this omission, assisted no doubt by an alert Library of Parliament preliminary summary of the bill, and the mistake has been rectified in what we now have coming from the Senate. But, and this is my main point, Mr. Speaker, the situation does give one reason to pause and ask the question: if something as significant as making a radioactive device, which appears clearly in the text of the relevant treaty, was missed, has anything else been overlooked? Or has there been some other slippage in the tightness or the accuracy of the drafting of this bill? We need to ensure this is not the case in committee. Now, the second reason there may be need for amendments, following directly on from the just asked question, is that the committee may need to consider amendments in that there is some reason to believe that parts of S-9 have been drafted in terms that are not just more general in their phraseology than the specific treaty articles they are meant to implement, but are broader in the sense of criminalization of more than is required by the treaties. Now, I will in a moment outline very briefly where this may be a problem in Bill S-9, but a prior problem may be that the Minister of Justice and officials before the Senate committee do not appear to agree there are any such aspects of overbreadth. The reason this is a problem, Mr. Speaker, is that such denial makes it impossible to go to the next stage of analysis, which is to ask whether overbreadth in relation to what is strictly required by the treaties is actually of any real concern. If the treaties permit states parties to go further in what they criminalize, and the treaties probably do permit this, then it becomes a matter of sound public policy discussion here as to whether we do wish to go further. But if the government denies that S-9 does go further, we can't even have that discussion. The third reason that we may need to entertain a small amendment or two in committee is that there may, and I emphasize here the word may, be underbreadth in terms of the coverage of an aspect of S-9 offences. Now, I may have misread the corresponding treaty provisions in relation to the sections of S-9 in question, but one reading of them is that S-9 may not go as far as required in one respect. And if this is the case, then our legislation would put us in non-compliance after ratification. Now, I'll identify this possible glitch in a moment. Let me now proceed with a bit more detail on these points to illustrate why it is that we may have to pay some close attention in committee. First of all, the issue of potential overbreadth. In particular respect to sections 82.3 and 82.4, and I do apologize to everybody listening, this will be as technical as it's starting to sound. Article 2 of ICSANT is rather inelegant in expressing the need for specific intent on top of general intent for some of the offences mentioned. It talks about any person intentionally possessing, using, making a device, and so on, with the intent to cause death or serious bodily injury, or with the intention to cause substantial property damage or harm to the environment. So the first point to note is this double use of intentionality does cause a certain degree of inelegance, and S-9 doesn't repeat that. S-9 uses simpler language, for the most part, going straight to the specific intent kinds of formulations, and this seems wise. But then the problem that appears on one reading of sections 82.3 and 82.4 is that the specific intent formulations of the treaty of ICSANT regarding use or damage to a nuclear facility are not reproduced in section 9, in S-9, and instead section 82.3 and 82.4 of the bill merely assume a general intent standard. This is because, again, this is a very technical point, sections 82.3 and 82.4, the acts in the acts listed after the words, quote, or who commits, unquote, are cut off from the specific intent references earlier in the provision. Now, in similar vein, the amendment to the CPPNM treaty on acts directed against nuclear facilities also has a specific intent requirement that S-9 does appear to omit. Another point about overbreadth, and here I'll just simply state it as a very clear problem of overbreadth, there's no doubt and no debate about this one, is that the references to crimes of threat in S-9 go further than necessary under the treaties. And this is actually very helpfully laid out in the very well put together legislative summary provided by the Library of Parliament. Finally, there is a provision in S-9 that talks about committing an indictable offence with intent to obtain material or a device versus the treaty provisions actually listing the specific other forms of offence that are attached to this search for this intent to obtain material or a radioactive device. So we've created a much broader tacking on of this notion of committing any indictable offense as opposed to the very specifically listed theft, robbery, embezzlement, fraudulent obtaining, and so on that are in the treaties. Now, this all is as dry as the honourable member from Gatineau promised it would be, but I did want to simply get this on record so that it helps us at the stage of committee to ask whether indeed this is a correct reading, and if so, what needs to be done about it. There is something quite significant, however, about the fact that if there is overbreadth in any respect, there's a multiplier effect that occurs throughout S-9. That's because a number of other provisions tack themselves onto the offences. 4 of them, in particular, are worth mentioning. One is the extraterritoriality of the scope of the offences. The second is that they enter into the definition of terrorist activity, which is thereby broadened. Third, the electronic surveillance provisions of the criminal code are kicked in by the offence definitions, as are, fourthly, the DNA samples provision of the criminal code. So it's not as if these offences are simply more broadly worded in and of themselves as the issue, which may strike people as slightly semantic issue. It's how you multiply the potential significance of that across all of the other provisions I've just listed, what I call a multiplier or amplification effect. Now, I mentioned the fact that there is possibly an odd twist here, Mr. Speaker, in that there may be one instance of narrowing of treaty obligations in S-9 in such a way that might mean that S-9 does not actually go far enough, and thus may put us in breach of the treaty. The new CPPNM amendment in 7 sub 1 sub D criminalizes, and I quote, the intentional commission of an act which constitutes the carrying, sending, or moving of nuclear material into or out of a state without lawful authority. End of quote. Yet S-9's section 82.3 makes the, quote, import and export, unquote, offense subject to the specific intent portions of those sections. Specific intent which is not actually in Article 7.1d of the treaty amendment. So this could possibly be a misreading on my part of the treaty amendment or of what is intended by S-9, but there does appear to be the possibility that we have under-inclusion in that respect. And all of this adds up to the fact that the committee will indeed need to pay some attention to whether or not this bill has been drafted as well and as tightly as needed, particularly in light of the fact that in asking questions to the parliamentary secretary just now, the responses that came back were fairly general, and it's not at all clear that the government has gotten its head around these problems, even despite the warning of some of these questions having been asked in the Senate. Now, Mr. Speaker, I would like to first say a few words about parliamentary democracy as it relates to this bill. You might assume that I am referring to the fact that the bill started in the Senate, the unelected second chamber of our Parliament. In fact, this is not my immediate concern, as compared to the fact that it is a much more real concern and an affront to this chamber that S7, on which debate started earlier today, first went to the Senate. As long as we have a Senate, the present bill, S9, with its fairly, actually after having listened to myself for the last 10 minutes, its very technical nature, may well be the kind of bill that can fruitfully be started in the Senate so that the House benefits from some preliminary cleaning up and does not have to allocate undue time to studying the bill. The fact the Senate actually caught the omission of the making a device offense may actually prove my point, in part. So, Mr. Speaker, my immediate democracy concern does not relate to the Senate. Rather, it relates to the methods we use in Parliament to implement treaties and statutes. And again, I'm not referring here to the mess that many in this room know exists with respect to the lack of consistency in the ways that statutes are drafted to accomplish implementation of a treaty. By one count, in a law journal article I read some time ago, there are well over a dozen methods employed, ranging from verbatim reproduction of treaty text to very general language that does not even hint at there being an underlying treaty motivating the legislative change. So while this is an important issue, and while it does bear directly on how it is that S-9 may be overbroad in parts, I will leave it for another day. So I turn to what my concern actually is, Mr. Speaker. What I do want to discuss now is much more procedural in nature. The way in which bills are introduced, presented, and reported from stage to stage is close to a travesty when it comes to the twin goals of transparency and accountability. Parliament, and thereby also the Canadian public, must be given every opportunity and tool to be able to understand what is in a bill, precisely what is in a bill, and how that content relates, in this context, to an underlying treaty or another international instrument, such as a Security Council resolution. But that is not what happens here in Canada. Treaty implementing bills almost always get plunked onto Parliament's desk with nothing resembling an overview from the government, let alone a roadmap from the government, of how a statute's provisions line up with related treaty provisions. Parliamentarians end up reading a bill as if they had a jigsaw puzzle to solve. They track down the related treaty and then try to connect the dots between it, that is the treaty, and the statute, with absolutely no help from the government by way of a commentary that could easily provide explanatory charts showing text side by side so that Parliament's role of scrutinizing critically and effectively can be facilitated. Instead, valuable energy is wasted at the preliminary stage of understanding what is going on in the relationship between the statute and the treaty texts. Here I'm speaking, as some of you will be aware, as someone who was not only a law professor in a previous life, but an international law scholar for over 20 years. So if there's anyone in a position to put the jigsaw puzzle together, it would be someone with my background. But even I find it very, very frustrating. But more importantly, Mr. Speaker, I find it undemocratic. Why? Anything that makes legislative details needlessly inaccessible gets in the way of clear and focused analysis and debate, both by and amongst parliamentarians, and in terms of how journalists and the public in general will have difficulty grasping analysis and debate if there's no well-presented document that makes the subject of analysis and debate reasonably easy to follow. At multiple levels, democratic scrutiny is undermined, and distance between Parliament and society is exacerbated. Without dwelling further on the details of an ideal system of clear and transparent presentation of treaty implementing bills, which, again, this bill is not. It is a treaty implementing bill, but it is not clear and transparent. That's my point. At minimum, government must be required to include within a bill a document alongside a bill, a document that does at least the following three things. First of all, the document should show in a side-by-side comparison the text of treaty and statute in a way that makes clear what the treaty is intended to implement. What the statute is intended to implement. Secondly, the document should explain and justify the method of implementation that has been chosen. For example, if general language is used or if a treaty text is reproduced nearly, but not entirely, in verbatim form from the treaty, we need to know why that decision was made. And finally, Mr. Speaker, the document should provide a clear account of what is not in the implementing bill by reason of the fact that Canadian law may already cover off the area, the fact that treaty provisions in question may only operate on the international plane, or the matter must be dealt with by a provincial legislature. In order to appreciate that this is not simply a cranky protest, Mr. Speaker, all we have to do is consider what everybody here knows about how inaccessible even basic bills are when presented to Parliament in terms of how well we can understand the underlying statute that's being amended. We also can refer to budget bills that don't come anywhere close to meeting OECD transparency guidelines. I think my main point, Mr. Speaker, is to draw attention in this immediate context of one problem we have with a very procedural dimension of accountability in this Parliament that is not alone in the way we deal with legislation. Thank you, Mr. Speaker.